So thanks to everyone for joining us today. My name is Elena Bowers. I'm a supervising attorney here at Legal Aid DC. And I'm here with my colleague, Molly Katchen, another supervisor here at Legal Aid. We are grateful for folks joining us and everyone's continued interest in taking these right to counsel cases, these housing right to counsel cases pro bono, and continuing to help tenants in our community preserve their housing and their subsidies. So please do, if there are issues, please raise your hand. There's a Q&A feature somewhere. So if folks have questions, I believe you can type them in. And I think that we're going to go ahead and get started. So this is a joint project by 6 organizations that all provide eviction services in DC. And so you may have one of these other organizations as your mentor. There we go. So first, just a basic overview of what the Housing Right to Counsel Project is, though most of you already know this as you've attended prior trainings. We place eviction matters with subsidized tenancies with pro bono counsel with the goal of increasing tenant representation in eviction cases. We focus on subsidized tenancies because, DC is an increasingly unaffordable city, and so tenants with subsidies are the most vulnerable. If they lose their unit, if they lose their subsidy, they're unlikely to be able to remain in the district. Most of you already know this, but the Right to Counsel Project has a few basic requirements for you to take a case and first attend the Right to Counsel training, which is sort of the 4-hour training that we hosted earlier this year. We also have a recorded version for folks who will want to take cases and have not been able to attend one in person. Connect with the experts at your firm or organization. Each of the firms have subject matter experts in these cases or mentoring these cases. So start by connecting with the experts at your firm. You will be partnered with a legal services mentor like Molly and I, or one of our colleagues at one of the other legal services organizations. If you could please, I said comment in the chat. I now realize the chat has been disabled. Could you please raise your hand, perhaps, if you have already taken a case through the Housing Right to Counsel Project, so we can get a sense of who is in the room with us. We've got a couple, 4 so far. Wonderful. Well, thank you for having taken some cases, and we look forward to seeing you take some more. And for folks who haven't taken a case yet, we aim to make it as manageable as possible to jump into a new practice area. So thank you so much. Today, we are going to be talking about taking more advanced cases. So we're going to be talking about notice to quit cases. We covered these in the original training, but we will be doing a 10,000 foot overview once again, just to make sure we're all working with the same vocabulary. And then we'll be talking about how to work up a new case. So you take a case and how to start and some practice tips there. These cases are often factually and legally more complicated, and so are more likely to go through to mediation and even to trial. So we're going to talk about some practice tips for preparing for mediation and trial. And then finally, we're going to talk about how to ensure, if and when you settle the case, that it's settled with an agreement that's in your client's favor that your client can comply with. So first, what is a notice to quit? Oh, Molly.
Okay, yes, that's me. Hi, I'm Molly Katchen. I'm also at Legal Aid DC. So first, we're going to talk very quickly about what a notice to quit case is. And hopefully this is not new information because you've already attended our prior training. But just as a refresher, a notice to quit case is a case where a landlord is alleging that the tenant violated their lease or there's a violation of the DC Housing Code. It's codified in 42-3501, 3501B. So you need an existence of a landlord-tenant relationship, some violation of obligation of tenancy, which means a written provision of the lease or a violation of the DC Housing Code. The obligation must be a substantial obligation, and that will come in a little bit later in some of our defenses. There has to be service of a legally sufficient notice to quit, correct, or vacate, and the terminology is used interchangeably between those 3 terms, but they all essentially mean the same thing. This is a condition precedent to filing a suit. So this has to happen prior to a case being filed in court. And that notice has to allow the tenant time to cure the alleged lease violation or vacate within 30 days. Except, which brings us to the next slide, in a one strike or criminal activity case, which is also a type of lease violation case. And one thing that I will just go back to that wasn't on the prior slide is that the important difference between a lease violation case and a non-payment of rent case is that a judgment that's entered in a lease violation case is non-redeemable, which means that once a judgment is entered, there's nothing the tenant can do to stay in the unit. They can't somehow fix it later. They can't pay the rent like they could in a non-payment of rent case. That judgment is non-redeemable. So once judgment is entered, the tenancy is lost. In a one strike or criminal activity case, these cases have no right to cure. And this is for tenants in public housing or a federal subsidy. And it's a situation where the tenant, guest, or other occupant under the tenant's control engages in criminal activity that threatens the health, safety, or right to peaceful enjoyment of the premises by other residents, or the tenant engages in any drug-related criminal activity on or off the premises. So these are generally even more complicated than your typical lease violation case, and there's no right to cure in this. So if the notice that you'll receive, the tenant will receive in this case will not have an opportunity for the tenant to cure. The elements are otherwise the same, except there's no right to cure. So the defenses that we typically will see in this case is denial of the allegations. Your client says, I have no idea what they're talking about. This wasn't me. I didn't do it. That your tenant does know what they're talking about and may have engaged in the alleged lease violation case, but they cured within the time period of the notice. And so they basically fixed the problem. Essentially, the notice is the landlord's opportunity to say to the tenant, you are doing something that's violating your lease. You have this chance to fix it. And so that cure period is the time to fix it. So one of the main defenses is, I fixed the problem. It's not ongoing. You can't evict me. Another defense that we assert pretty regularly is that the violation is de minimis. So it doesn't meet that substantial standard that was on the previous slide. And retaliation, meaning the landlord is trying to evict the tenant because the tenant is engaging in some legally protected activity. This often comes into play in cases where the tenant is organizing in the building as part of a tenant association, or more frequently when a tenant has reported housing code violations and is complaining about the conditions in their unit. If there's been complaints within 6 months prior to the eviction being filed, there's a presumption that the landlord is acting in a retaliatory manner. That presumption can be rebutted by the landlord, but it is a strong defense to assert. So asking your client about housing code violations in these types of cases and whether or not reported it is very important. It's not housing code violations themselves are not the defense. The defense is the act of reporting it and the landlord taking a negative action against the tenant based on the reporting of those. Other defenses that are asserted in this case, less frequently, is that there's some sort of discrimination, or that the violation is a result of an intrafamily offense.
So now we're going to talk about working up one of these cases. Congratulations, you agreed to take a notice to quit case through the Housing Rights Counsel Project. We're very excited for you. So now what do we do? You work up the case. You start by using the skills you use in your sort of everyday work in other areas of law. You examine the papers for technical defenses to understand the scope of the claims against your client, and you plan for the initial client interview. It's really important to come up with a plan for the client interview based on sort of what the allegations are, so that you can get all the information that you need sort of in as sensitive a manner as possible. Once you have wrapped your head around it or have started to wrap your head around the case, you want to meet with your client. We recommend meeting with your client in person, at least at the first instance. We think it's helpful to establish trust with the client if you can meet with them either at your offices, at a library, at their house, so that you can get to know them as a person and sort of on a human level, in addition to beginning your factual investigation, figuring out what your client's story is, what other people you need to talk to, what information you otherwise need. You want to be incredibly strategic about discovery in these cases because, so many more of these cases get to the point where you're pressure testing the landlord's theory of the case. And so you need to ask the right questions. You need to request the right documents and sort of think critically about what your discovery options are. In these cases, you get 10 interrogatories and 10 requests for production of document by right, but you will want to think about if you need to, actually, there's an error here. If you want to subpoena someone during the discovery period, you don't actually need leave of the court, but you do need leave of the court if you want to try conducting depositions in your case, which can be a very useful tool in these cases, but one to think about very critically. And then you'll want to conduct your investigation, and that's outside of just talking to your client. It's talking to other potential witnesses, etc. Some additional tips for your first client meeting. You should really focus on building trust with your client. These cases often involve allegations that can be sensitive, allegations of criminal activity or other stigmatized behavior. So we're talking about allegations of hoarding, or the landlord is saying that your client is loud and obnoxious, and sort of, human reaction to get defensive. And so it's very important to have a plan for how you're going to talk to your client in a way that recognizes them as a person and sort of validates their feelings of injustice potentially in these situations. And you will want to make sure that you have a plan, including addressing reasons that they may not want to trust you. And this is when it comes to everything from where you want to meet them. Do you want them to come to your office? How will one of our clients perceive coming to your office versus meeting sort of at a meeting space in their neighborhood or at their house? We advise addressing reasons they may not want to trust you head on when you feel that, when you sort of start to notice those reasons popping up. When you meet with your client, you'll want to review all of the pleadings and all of the notices. You'll want to hear from your client what they agree with, what they dispute the characterization of. Oh, I mean, there was an incident, but it wasn't a fight, or, sort of whatever it is. You'll want to sort of know exactly what you're working with in as much detail as possible. And you'll want to talk to your client about sort of what other factual investigation makes sense. Like, who else do we need to talk to? Who was there? Is there any documentation? And sort of use your client's expertise in their lives to assist with your investigation. You'll also want to discuss a plan for keeping in touch, sort of how they can reach you, how you can reach them. It goes both ways. You'll want to set clear expectations, both of your client, the expectations that you have of your client, and you'll want to understand the expectations that your client has of you, about things like staying in touch, about in-person meetings, about your timeline, what comes next. I think that this all goes to setting expectations well, goes to sort of building and developing and maintaining your client's trust in your handling of their case. Client counseling is not something that's going to be one and done. This will continue to be an important part of your representation of a tenant in one of these cases. As I've said a few times, trust in these cases is key. It's ongoing. The process of developing and maintaining your client's trust is ongoing, and your client relationship is really important in these cases, so that you can help your client have an honest assessment of sort of what's going on and what their options are. You want to, in these cases, more than non-payment of rent cases, you sort of always want to be planning for trial. Your client counseling should be in the context of what their trial prospects are. You should be continuing to pressure test your theories of the case, defenses, issues that you might have with proof or the other side might have with proof, as well as potential credibility issues, either of your client or your witnesses, and sort of how that will, how you think you'll fare at trial, so that you can help your client get to a realistic expectations of how the case will proceed. And then you want to be thinking about, and when appropriate, talking to your client about whether their goals match the practical realities and sort of what their likelihood of success is. And these cases are harder cases. These cases, if we take them to trial, we are more likely to lose in some cases, or landlords, excuse me, or landlords are more reluctant to settle these cases. And so it's important to continue those conversations. In all cases through the Right to Counsel Project, tenants have a subsidy that helps them pay their rent. In all cases, the subsidy matters a lot in terms of establishing the legal framework that you're working with for this case. In notice to quit, and especially criminal activity cases or one strike cases, as Molly was discussing, the subsidy matters a lot. So you will want to, in our referrals, we will often identify the subsidy as sort of one of the broad subsidy types, public housing, site-based Section 8, a voucher. And when you take the case, you will want to continue to investigate if there's a more specific subsidy type or more specific regulatory framework that your subsidy is under that changes your clients' either obligations or their rights and risks. And so that's something you want to talk about with your client, but you'll also want to consider in discovery. And so sometimes we need to go outside of your client's sort of story or representation, or the papers that they have in their possession, to figure out what the subsidy type is. And it does get complicated. Subsidy types, as much as anything else, get very complicated. So please, if you find yourself unsure, please ask for help. Your firm resources and mentor and your legal services mentor can help with complicated subsidies. Like sort of many other legal frameworks, sometimes we can give you a little bit of advice of where to start looking if you're in one of the more complicated subsidy areas. So you will want to plan and conduct a thorough investigation in these cases. You will want to visit the unit, the building. You'll want to if there, this is we are talking about sort of the more difficult of these cases. There are some cases where this might not be relevant. There are some cases under here that are recertification cases where your client just has failed to recertify, or there are some cases under here which are failure to pay all utility bills where this might not be relevant. But for cases that are alleging some sort of act or incident or behavior or condition of the client or the unit or something like that, you'll want to go in person to visit the building or the unit, walk through the location of the incident, see the conditions, see if there are cameras documenting the conditions that you can ask for evidence in discovery, sort of see if your client's story holds up under sort of your observations of the situation, see if the landlord's version of the story holds up under your observations, is very, very helpful. Take pictures and or video if helpful. You want to use a legal assistant or other investigator to the extent that you want to start planning for how you're going to introduce them at trial, especially if you want think that you don't want to introduce them through your client for any reason. You want to get your client's documents to the extent they have them. You may or may not be asked for discovery in these cases. As those of you who have already taken cases know, our landlord's counsel is varying degrees of competent and effective. So you may or may not be getting discovery requests. So you can't wait until you get those discovery requests to start going through your client's documents and your client's story. So you want to sort of just start doing that from the beginning as part of your investigation and see what you have already and what may be missing. I see a hand raised by a panelist.
That was me. We have a question in the Q&A. Would
Wonderful.
consumption of cannabis be grounds for a notice to quit, considering it is illegal on the federal level, but has been decriminalized in DC?
That's an incredible question. Unfortunately, yes, it is still, because it is still a criminal offense, a federal criminal offense. And these are federal, well, I guess it's more complicated than that. Of course, it depends on the subsidy type. If it's a federal subsidy, then yes. If it's a local subsidy, then maybe not. I haven't had a tenant with a local, I'm trying to think it through. I don't know that they're, I don't know. For federal subsidies, yes. For local subsidies, like if you have for local subsidies, it's usually a voucher, so it's placed somewhere. So the eviction might be, wouldn't be a one strike case, so wouldn't be considered criminal activity, but might still be a lease violation. I think is my sort of initial analysis, but it's a good question, and it's another reason that subsidy matters. I saw Molly nodding and puzzling, so I think.
Yes, I was just going to say, I agree. I think that it is what you said is accurate. We haven't seen very many marijuana cases recently.
No, we haven't. And, I think that, I think whether you want to take that case to trial, maybe under a theory that it's a de minimis crime, if it's not a crime in the city, like it would be a really interesting jury test. Thanks for the great question. If others have questions, please do drop them in. I really appreciate it. Anything else, Shula? We move on.
Good to move on.
Great. So you will want to talk to witnesses to the extent that there are witnesses to the incident, to the extent that there's someone else that your client relies on. You will want your client's consent to talk to people. I think, as we mentioned earlier, some of these issues are either actual allegations of criminal activity or other sort of highly stigmatized, potentially highly stigmatized behavior or allegations. And so you want to talk to your client to make sure that they're comfortable with you talking to other people about what's going on before you talk to other people. Yes, another one.
I spoke too soon. Okay, the next question is, what is the burden of proof in eviction cases, and does it vary? If a tenant raises an affirmative defense, does the burden shift to the tenant in whole or part, and what is that burden?
Yes, it's a civil case, so it's a civil burden. And if you raise an affirmative defense, the burden does shift. So like, in non-payment of rent cases where we file counterclaims, the burden obviously shifts there. I think, yeah, I'd have to think a little bit more about affirmative defenses. I mean, so if you raise retaliation, right, that has its own burden shifting framework. If you raise discrimination, there's a different burden, right? So you have to like get a little bit more into sort of what the facts are to figure out that. But that's also another great question to talk to either your firm resources or your legal services mentor when you're getting into the facts there.
Yeah, so we have a follow-up, which is,
Great.
so in order to evict, the landlord just has to show preponderance. In order to cure non-redeemable offenses, does the tenant have to show by a preponderance that they have cured?
Yes, on both parts. Right. And so, you'll often see these cases follow criminal cases to the extent that there's a criminal case, because if someone pleads or if is convicted, then that can be used as an easier way of evicting people. But it is definitely a lower bar. So being acquitted in and of itself is not enough to show that, to meet the burden, to show that you have to win in a eviction case. Great questions. Okay, I'll move on, but continue to put in your questions as you have them, please. So discovery is key. I feel like often it's very likely that many of you in your practice areas have discovery experience already. And so that's awesome. And maybe quite a bit more discovery experience than we do, but we focus on this very, very narrow area. So once you know what the landlord is alleging and what your client says happened, you want to tailor your discovery so that you can get out all the facts that are at play. You want to know everything the plaintiff thinks they know and everything that they think they can prove about the specific allegations, both in the notice and allegations about the failure to cure. I think an important practice point is that you need to stay on top of discovery deadlines. As I mentioned before, this is not something to rely on, but often our opposing counsel in these cases are varying degrees of effective or ethical or, etc. So you will want to, if and when they are late in producing discovery, you will want to follow along the discovery deadlines very closely, and you'll want to have them calendared so that you are prepared to send a letter saying that you're going to file a motion to compel and file the motion to compel on time, seek attorney's fees as a sanction for failing to comply, all of that, both because you need the discovery and because it continues to get your client leverage in settling the case. So you want to definitely be pushing forward, as I'm sure you all will. I see another question popping up in the Q&A.
Yes, I'm going to have Sylvia answer this. The question is, how would the retainer/scope of representation agreement for a pro bono client be structured for a government attorney?
I think that's a little bit more of a detailed question that we can focus on. I think that if somebody has a question about the retainer, we can discuss that more specifically with our federal government attorneys. I think also the DC Bar Pro Bono Center, who is their mentor, can also provide examples of that retainer. But by and large, we don't provide guidance on what is in the retainer. So I would suggest for our federal government attorneys, I would touch base with the DC Bar Pro Bono Center to see if they have a sample, but otherwise we don't generally dictate what is in there.
Yeah. Also, the person who asked this question works at OAG.
They're not a federal government attorney then, so they would be. So
OAG also has samples.
We have samples for OAG. We can, if they want to reach out to us directly, we can answer that question.
Okay, I'm gonna move forward through the end of this section, and then we can address any remaining questions at that time. So you want to stay on top of discovery deadlines and don't let the plaintiffs bring cases that they're not willing to engage in and prosecute. So you want to consider whether you should file a motion for depositions of key witnesses. do witnesses have evidence or testimony that's necessary that the landlord has not produced? We have tried conducting 30B6 witnesses in some of these cases when the landlord has either failed to provide deposition or provided failed to provide discovery, excuse me, or provided inadequate discovery. And so it's another way to think about, another tool in your tool belt. You want to consider if the plaintiff or plaintiff's counsel would try to depose your client in return, and sort of what impact that might have based on your client's particular circumstance. And just a practice tip, please check with your mentor before moving to depose a witness in a criminal case, just because of sort of the extra risks there for your client. Okay, we are at the end of this section, and Molly's going to start talking about preparing for mediation and trial, but I just want to check, make sure we don't have any pending questions.
I don't think we do.
Great.
So I'm going to talk about preparing for mediation and trial. So now you have done your investigation, you have a good handle on the facts. So now what are your next steps? So the first thing to consider is whether or not you should move for summary judgment. And in considering that, you want to think about whether or not the plaintiff has produced sufficient admissible evidence in their discovery to prove their case. If they haven't, you should think about whether or not you should move for summary judgment. You can move for partial summary judgment if you think there are certain things they can't prove, and could resolve part of the case in your client's favor. One thing to keep in mind when you're moving for summary judgment is whether or not that might prompt a cross motion for summary judgment, and whether or not, you could survive that. But it's definitely something to consider, particularly if the plaintiff's discovery is very bare bones and it doesn't seem like they have enough evidence to win, to prove their case. And just motions for summary judgment, the deadlines are in Rule 16, but it's 30 days after the close of discovery. So just keep that in mind in terms of timelines. So the next step is to prepare for mediation. You want to meet with your client well in advance of mediation, talk to them about what mediation is going to look like. When your case gets set on a trial track, in this case, like a jury trial track, the court is going to ask whether or not you want mediation to be virtual or in person. So you should know, which way it's going to go which way it's scheduled for. You want to talk with your client, sort of, if it's virtual, think about whether or not you want to be in the same space with your client. Do they have any technology concerns that would make them not able to log on to mediation? All of that kind of stuff, sort of just the practical things. But you also want to talk to them about what is realistic and not realistic in terms of settlement and trial, and set expectations. You want to talk through them what mediation is going to look like. Both parties will, everyone will be together in a room. There'll be an opportunity for folks to talk together. And then likely what happens in these mediations is that each side is sent to breakout rooms, and your client and you have time to discuss sort of what was brought up in the big group. But mediation, particularly in these cases, can be very difficult for some clients, especially if they don't have a great relationship with the property office or someone in the property office. And so just talking to them about that in advance of mediation, I think, is helpful, so that you can be prepared to ask to go to a breakout room sooner, or if you're in person, step out of the room briefly if your client needs a minute, and just that you've thought through a plan for that if the relationship is if they have a negative relationship and it's going to upset your client. So think through that. You want to be prepared to discuss defenses and weaknesses in the landlord's case. And so ideally you've completed as much of the investigation as possible, and you have a good handle on the record. So hopefully discovery has completed at this point when you're moving to mediation, so that you're coming to the table with all of the facts in front of both sides to come to some realistic solution or settlement, if that's a possibility.
Molly, we have a question. Is mediation typically done through the court's multi-door process or something else?
Yes, it's done through the multi-door resolution center. So the building is sort of across the street from the landlord tenant court. But yes, it's all done through multi-door. Just one practice tip is to check with your mentor before settling a case. Oftentimes our attorneys will, if we think we might be able to settle a case, we'll write up some terms of a draft agreement before mediation and come to mediation with those terms. Talk to your mentor about that. You know, we'd be happy to look at, you know, terms in a draft agreement to make sure you're thinking through all of the, you know, consequences of that settlement agreement. But I should definitely be checking with a mentor before settling any of these cases if possible.
I have another question, which is, how early in a case does a familial status discrimination defense have to be raised? Could it be waived if you raised a different issue on an earlier motion to dismiss, for example, insufficient service, and have since set dates for discovery/mediation?
So generally all of the defenses if you file an answer and jury demand. So if you want to jury demand a case, you have to file a written answer. And so defenses are generally all raised at that point. You can amend that answer within 21 days as a matter of right. After that period of time, if you want to add an additional defense, you have to ask for leave of the court. The courts typically grant leave unless there's reason not to or prejudice to the landlord. And so the standard is fairly low to amend an answer, but typically you want to raise as many defenses as possible when you file your answer and jury demand. So I think at this point, these are all really great questions, and we really appreciate you all engaging so much in this subject matter with us. I think we're going to try to get through our presentation and then do a question and answer period at the end, if that is okay with folks, just to make sure we get through the material. But again, we really appreciate all of the thoughtful questions and everyone engaging in this material. Okay, so coming back to preparing for trial, you know, preparing for trial in a notice to quit case is preparing for trial in any type of litigation. You want to have a trial outline that sets out your elements that the landlord needs to prove, evidence, physical and documents, think through witnesses, testimony, how you're going to get in, if you have evidence that you want to introduce, how you're going to get that in. I think it's really important in these cases to be thinking through what the landlord needs to do to prove their case and how they need to get that information in, because we've had instances where landlords haven't been able to get in crucial documents under the rules of evidence. And as a result, they weren't able to prove their case. So be thinking through what they need to prove as well, so that you can be prepared to object if they're not doing it properly. Sorry, the words are coming up slowly and I don't remember what all the slides say. So, you know, one of the most important things about preparing for a trial is to develop a theme and theory of your case, right? You want to be able to tell a story about what's happening and a story from your client's perspective about what's happening, because that's going to be more persuasive to judges and juries to sort of lay out why we're in this situation and what's happening. So you want to have sort of a short story that's sort of weaved through all of your opening, evidence, closing, to kind of get your client's perspective on what's happening out there to the judge. It's especially important to juries, I think, to sort of be telling your client's story this whole time. You know, you want to have your theory and theme account for good and bad facts, right? You know, you want to highlight the good facts, but if you ignore all the bad facts, that's not going to help you either. So you have to come up with a way to address those bad facts and try to limit the impact they have in the case. Get creative with trial motions. Prior to going to trial, you'll have what's called a pre-trial conference. And all of these are set out. I think we talked about this in the last training. There's guideline, there are timelines for when these have to occur. So you have to have a meeting with the landlord's attorney prior to submitting your pretrial statement, in which all the parties have to submit all of their evidence and witnesses. So when you get that information, think about whether or not any of the evidence they're seeking to admit should be excluded, and through any kind of motion in limine. If you think evidence they're trying to get in is not relevant or is not relevant or could be, unfairly prejudicial to your client, all of that stuff. So think through different ways to exclude evidence that you don't think should come in trial, right? And you want to do that in a motion in limine first, because if you resolve that at the pretrial stage, the jury doesn't hear anything about that at trial. So, at trial, you want to make sure that the plaintiff, the plaintiff's burden, they have to prove each element with admissible and relevant evidence. So think about whether or not they have the right witnesses to enter different documents and evidence, whether or not that witness is competent to testify on that issue. Is the witness using hearsay? All of sort of your typical things that, come up in evidence practice if you are using that, or if not, what you learned in law school, to think through ways in which you can object and force the landlords to, make their case with admissible and relevant evidence. You want to have a motion for a directed verdict or a motion for a judgment ready to say after the plaintiff rests that they haven't proven their case. And be prepared to object.
I'll just add, if you are rusty on evidence, we all are a little bit, and if you need sort of quick reference guides to take with you to evidentiary hearings or trials about sort of common objections and stuff like that, that's something you can check with your firm, obviously, or organization, but also you can check with your mentor for some of those resources as well.
So obviously we hope that we win at trial, but you want to be prepared for what's going to happen if you don't win at trial. And so you want to be thinking about whether or not there are any arguments for appeal. Are there, any errors at the trial, or anything that you think is an appealable issue? Notice to quit cases generally have sort of more legally complex and sometimes novel arguments. And so be creative in thinking through those. But if you want something that you want to have thought about prior to the trial, obviously you're not going to know what happens until the trial itself. But if you start thinking about that prior to trial, you'll have a better framework for sort of digesting what happened at trial to determine whether or not there are any grounds for an appeal. I think there's one more.
Yeah, I'll just flag that you need to move quickly to stay any eviction. So that's why we encourage you to be prepared at trial.
Yes. And depending on the judge that hears the case, you may need to file a motion for review before filing an appeal.
So we want folks to be litigating, we advise folks and hope folks are litigating these cases as if they're taking every single one to trial. We think that's the way to make sure our clients are represented, the best way we are able. That being said, most of these cases still do settle. They often settle sort of later in the case, on the eve of trial sometimes, but we still want to review sort of how to structure or how to, what to think about in order to get the best settlement for your client. So sometimes settlements come out of left field. You were gearing up, marching towards trial, but now you're ready to settle. So we want to make sure that you're settling on terms that give you opportunities to protect them, especially if there's some sort of violation alleged at some point. Like we said earlier, please do check with your mentor before settling. We understand that these happen quickly, but we want to be flexible and help you. I think if folks have one takeaway from this whole training, it's like, please check with your mentor before settling these cases, just in case there's some sort of pitfall given the severity of these cases and your client situations before, so that we can make sure they're protected. So most lease violation cases end up settled lease violations and criminal activity cases are settled with some either dismissal of the claims or some sort of good conduct agreement. Sometimes it's necessary to settle a vacate or a move out agreement, but that should be sort of the last line of defense in most of these cases, especially where there's a site-based subsidy. So, you'll want to be thinking about during sort of all parts of the case is if there's a good conduct agreement that you think is possible. You'll want to talk with your client about their ability to comply with whatever the good conduct is. It's usually sort of refraining from doing whatever conduct is alleged in the notice and in the complaint. Sometimes it's something having to do with your client's mental health or something having to do with your client's kids' loudness that are outside of your client's control. And so you'll want to think about sort of how feasible it is for your client to actually control the conduct that they're signing a good behavior agreement for. So you'll want to sort of some important considerations for good conduct agreement. The shorter, the better for the amount of time that they're agreeing to. So, I've had landlords attorneys say, will not do something for 5 years. And 5 years is a long time for your client to be beholden to a certain settlement agreement and sort of on the precipice of eviction if they violate the settlement agreement. So you want as short of a timeline as possible. Puts your client in a better position. You want to define the behavior that your client is agreeing to not conduct or conduct, I guess, in some cases where there's like cleaning or something like that. But you want to define the behavior as specific as possible. So rather than will refrain from loud and boisterous conduct, which can be anything, and gives the landlord a lot of opportunity to pursue eviction for violations in the future, you want to say will avoid playing the television between the hours of 10 p.m. and 6 a.m. or something like that, right? So that you can really narrow down what the alleged behavior is and sort of what the actual issues being raised are and how to narrow it. And then you'll want to limit the enforcement mechanisms, build in a requirement for notice to be provided. So like if there's a noise complaint, notice will be provided to the tenant and she will have another opportunity to cure like a mini notice to quit essentially before the enforcement mechanism kicks in. I see there's a question. What are typical protective terms in a kid's loudness case? A number of additional complaints, etc. I mean, I am hesitant to advise a client to agree to anything if the allegations actually stem from kids being loud, because I think it's like familial status discrimination and unreasonable. I think you get into harder areas when it's like teenagers and teenagers behavior. But if it's like a kid's jumping, I wouldn't advise a client to agree to almost anything. You can agree to things like the client will install or like add a rug or a rug pad or something like that, which is like much more narrow. But yeah, those are hard, right? Because some of our clients live in apartments. The apartments sometimes have thin walls or, thin flooring, cheap construction, and, you can just hear. So it's a balance between sort of what you would get at trial and what your client can actually agree to. So happy to talk to whoever this is in that case more specifically, but you can build in opportunities for cure, opportunities to notice, make them prove a higher burden of proof at a hearing on any alleged violation. Sort of you can agree to stuff like that. You can also consider whether they can be moved to a different unit. Can they be moved to, if the downstairs neighbors are the ones complaining, can they be moved to a ground floor unit, etc. So we really, really encourage folks to be creative and think creatively about possible settlements. We had a tenant who agreed to a move out agreement, which we agree, we think is an absolute last resort in most of these cases, especially in site-based properties. Remember, there are two types of subsidies, some that are tied to the unit and some that can move with the tenant. If your client has one that can move with the tenant, a move out option makes a lot more sense. If it's a site-based one, it's absolutely the last resort. But we've had clients like agree to them as long as they show that you're, but there's no timeline as long as you show that you've conducted a certain number of searches or a certain number of applications per month. So they like end up going on for a long time and building your client a lot of opportunities. So the next question tees up my next point. Does the representation typically end at settlement or continue to the notice to show cause phase if the client or landlord subsequently violate the terms of the agreement? So I think there are two things that determine that. I think one is your engagement letter or your retainer will determine whether or not it ends at settlement or trial or with some or with enforcement. But you will, if there's a violation, you will be counsel of record. So you will have to show up. If your retainer says you won't be involved in enforcement, then you may have to take additional steps with the court. In our cases, you will be on a counsel of record for the court. And so you will get notices, et cetera. And so you still have continuing obligations to the court. So, I think that's a complicated question for you to talk with your firm or your organization about. But we would recommend that you build yourselves tools so you get notice far in advance. You get an opportunity to see witnesses far in advance. So you can turn any sort of motion to enforce or like motion for judgment into sort of like a mini trial on what the allegations were and really pressure test the landlord claiming violations. So, like we said, we want you to be creative. Are there pretexts or agendas behind the party's actions? Can your client resolve those if it's not actually the direct, right? Is there something else motivating this? Are there remedies that one of the parties wants the court can't order at the end of trial that give you sort of extra leverage or extra bargaining tools that are like a little bit outside the case, but might improve your client's position? Can you create additional opportunities if your client makes a mistake or has difficulty complying? Like we talked about, sort of building in notices, many opportunities to cure, etc. Being really creative with those. Just are there other considerations? And this is a great time to check with your mentor if you're stuck. Get creative and tap the available resources to get the best possible result for your client. That being said, I think we've gone into how to work up these cases, how to think about sort of some of the opportunities of trying these cases and how to settle these cases. We hope folks feel a little better prepared to take on one of these more complicated notice to quit cases. I see we have about 5 minutes left and we're happy to take questions. And I won't speak for Molly, but I can stay on after if questions abound. And then the slide deck has already gone out. I think Molly and I's contact information maybe isn't in the slide deck, but we could circulate that after the training. If folks have questions, we encourage you to come to us or your mentor on the particular case or your firm, of course. So I'm just waiting to see all the hands pop up. I think we can, if folks want to raise their hands, we can let you ask your question directly, or if you have questions, you can also type them into the Q&A. If folks are starting to jump off, we really appreciate your time today and all that you will do in these cases. All right. I think I can ask, there's a way. Gwen, have we unmuted you?
I think I am. Can you hear me?
Yes.
So first of all, thank you for this refresher. Just wondering, in the event that there's actually a one strike eviction case that we get, how do we go about getting police documents? I realize that you can get them to discovery, but sometimes it's too late by then. And I'm just wondering if there as a process or anything that we can do to get police reports and things like that sooner, because it can be vital for even crafting discovery requests and motions and things like that.
Yeah, that's a great question. So you can go to the main police building that's like by the courthouse and request police reports, or you can go to whatever precinct that the complaint or the criminal activity was in. I think that we encourage people to be cautious about obtaining those documents and obtaining physical copies of those documents, because we don't want to do their discovery for them. And if you get discovery requests, you would have to turn them over. So just sort of be mindful about whether you're requesting them or whether you're looking at them, and sort of how to balance the competing needs there.
Gotcha. Thank you so much.
Thank you. That was a great question. Emily? Yes. Hi, Emily.
Hi. So I understand that like the answer is probably it depends, but could you just speak generally to like from the time we pick up a case to its resolution, what those like timeframes may look like? Like if the case like goes like settles in mediation or goes to trial or like something else.
Yeah, that's a great question. So, you know, the timelines, I feel like before the pandemic were a little more predictable. And after the pandemic, they've been a little more varied. And so, you know, I will preface, it totally depends, yada, yada. That being said, I would say, with the right combination of factors, including a landlord's counsel who participates in the case, which we do not guarantee in any way. I would say from picking up the case and doing the initial hearing to mediation should be about 4 months. And so I think that that would be the first sort of chunk of time, settlement opportunity. I think it's sort of unlikely that they'll settle before that 4-month period would be my best guess. And then after that, it is truly the Wild West. If it's a bench trials right now are being set out about 7 months, which is the longest I've ever seen. And that's, you know, for a combination of reasons, including like court vacancies and other stuff. So that is really long. I think that I would say jury trials maybe are about the same, even though it used to be that bench trials were like much shorter. I would say jury trials are about the same, and the pretrial conference and the trial could all be scheduled within another 6 to 10, 12 months. So I think, you know, on the short end, 4 months, on the long end, like 1.5 years. But 1.5 years really, I think, would be the outside for some of these. For some of our clients, time is good in these cases, right? There is some number of these cases that are not winnable cases, where we think it's still very beneficial for tenants to have attorneys to exert their rights, but ultimately, like, the client is likely to be evicted or move. And so for some tenants, time is the goal. And so in those cases, like, there are tools to get more time. But that's a great question, Emily.
Can I ask another question?
Yes, I will actually say, like, motions for summary judgment could shorten that timeline if, you know, one way or the other. What was your second question?
For the investigation piece, are you using investigators or like another person? Just like, do you worry about like impeachment at like trial, or like if you are the attorney on the case and you're doing the witness interview or you're gathering the information yourself, like do you use investigators? Like,
yeah, we usually use we try to use investigators or legal assistants, or you know, we try to have someone else on the call with us, even if we're the one asking the questions. We have someone else who's able to review it.